Good afternoon. It is one of the real delights of my job that I get to introduce a lot of people, many of whom are worthy, some of whom are really a lot of fun, and that's a narrower category. My old friend Linda Fairstein is in it. Linda graduated from the law school in 1972, and she went to work in the district attorney's office in Manhattan. I bet many of the students here don't know the history of that office, but there have been about 40 years of elected DAs in Manhattan, and I believe we're on number 3. And Linda went to work for the legendary Frank Hogan near the end of his long career, and just before the beginning of Robert Morgenthal's career. He's still there and running for re-election. 2 years after she went to the DA's office in 1972, that office created the first prosecutorial unit in the nation devoted to crimes of rape, sodomy, and sexual abuse. And 2 years after that, Linda Fairstein became the head of that unit. She remained the head of the Manhattan Sex Crimes Unit for 25 years until she stepped down in 2002. And as I read the record, during that time, she effectively had 3 simultaneous careers. First, she was a fabulously successful prosecutor. Bob Morgenthau, who, by the way, there's a chair here, which I held for a while, that has Bob Morgenthau's name attached to it, thanks to some friends of his, and he's a kind of honorary member of the Virginia community. Bob Morgenthau describes Linda as the most prominent prosecutor of sex crimes in the nation, and that is certainly true, as the statistics confirm. According to the New York Times, out of every 100 prosecutions annually, which is an approximation, virtually all of those involving what we would call colloquially stranger rape resulted in convictions. And in the much more difficult cases where the perpetrator and the victim knew each other in advance of the event, the conviction rate ran between 60 and 80%. Linda was a pioneer in what is now common and a backbone of sexual assault prosecutions, which is the use of DNA evidence to identify sex offenders. And her conduct in achieving these successes as a prosecutor also won general admiration from the New York bar, which doesn't always side with prosecutors. As the New York Times said when she stepped down, and this is a quote, "Ms. Fairstein has been widely viewed in the legal community as skilled and fair, treating victims with delicacy and the accused with vigilance, and sifting through competing claims and sometimes ambiguous evidence." Second, in addition to being a wonderfully successful prosecutor, Linda also has been an active and equally successful advocate of law reform, both in the definition of the offenses dealing with sexual assault and also in the administration of the criminal justice system in such cases, which may, on balance, be more important. She was a leading advocate of New York's rape shield law, which prohibits what used to be fairly common, rummaging around in a complaining witness's background in order to show unworthiness or promiscuity. She also played a major role in eliminating the traditional requirement of earnest resistance by victims of rape. This requirement was objectionable on several levels, it seems to me, but at least one of them is just that in a symbolic or ideological way, it sort of shifts to the victim the burden of proving a certain kind of conduct, gets the focus wrong. And that has been reformed in New York as elsewhere, in no small measure due to Linda's leadership. She was a major force behind the New York Sexual Assault Reform Act of 2001, which provided advantages to the prosecution in so-called date rape cases and also in cases of sexual assault accompanied by the use of drugs. And third, Linda has done repeatedly what academics only dream of, which is to write books that sell. She is the author of several bestsellers, including Likely to Die, Cold Hit, The Dead House, which was chosen as a best book of 2001 by the Washington Post and the New York Times, and most recently, this is my copy, assigned to me, you have to get your own, Entombed, for which I thank you. And she's also written, in addition to this array of successful novels, she's written an important nonfiction book, Sexual Violence, Our War Against Rape, published in 1994. And finally, Linda Fairstein provided the inspiration for one of the law school's greatest assets. It's the Linda A. Fairstein Public Service Fellowship. And that fellowship was designed to encourage law students to engage in public service. It does that by providing a $5,000 stipend in the recipient's third year of law school and in the first 2 years after graduation. And by that relatively modest contribution, we try to provide some impetus and encouragement and recognition and reward for people who are entering public service as a career. This is, of course, in addition to the loan forgiveness program, which has the same basic rationale. As the Fairstein Fellowship lasts for 3 years, at any given time there will be 3 recipients, and we're hoping, Linda, to be able to award 2 a year pretty soon. But at any given time, at present, there are 3 recipients, and the money necessary to provide all those payments comes not on a current funds basis. I've lapsed into dean speak here. The money necessary to pay those payments comes as the income from an endowment, and that represents a considerable sum of capital devoted to this purpose. It comes from Linda's classmates, who gave the money, devised the program, dedicated it to the Linda A. Fairstein Fellowship in Public Service in Linda's honor, to record in perpetuity their admiration for her leadership and her example. And I think it's also fair to say that it is a tribute to the deep affection in which she is held by her classmates and by all of us who are pleased to know her. One of the law school's most distinguished alumna, Linda Fairstein.
Thank you. I don't know why I've stayed away so long. I started my day with an introduction by Professor Smith that came close to the generosity of this one, but this was not only generous and warm, means a great deal to me. When I arrived here in 1969 at the old law school at Clark Hall, and some of you heard some of these points this morning, I had a very serious commitment to the study of law and absolutely no idea of what my career path would be. And everything that has followed since my graduation in 1972 up to the present, and the combination of the practice of law, which I still do very aggressively, and literature, if we can call crime fiction literature, and I do. But that literature is completely infused with and was given birth by the practice of law. So it all came from the great education I received at this great school, and I am thrilled and honored to be back today. When I arrived here in 1969, I began to study, and for some reason, gained the attention of the man who was then the dean, Monrad Paulson, who was my criminal law professor and criminal procedure professor from the first weeks of school. And I was one of those students, those among you who are not law review, those among you who don't raise your hand every day to answer questions knowing all of the information. I was one of those people. I was probably, if the class could have voted on the least likely person to come back addressing the class and have this wonderful scholarship in her name and be a best-selling author writing legal procedurals, I would not have won that contest. So study on, all of you who are just below that ridge. There is a great future and a great life. Monrad Paulson, for some reason, took an interest in me. I came alive in those classes at first, criminal law and criminal procedure, and we talked early on about my interest in public service. I had graduated from Vassar. I was in the last class that was all women at Vassar, and I wanted to write. I had spent a lifetime dreaming about being an author. I had a very loving and practical father who used to say to me, "You have nothing to write about, so think about a career." And it was truly public service. It was really being in junior high school and high school when John Kennedy was elected and inaugurated and made that inaugural speech, "Ask not what your country can do for you." And many of us, that generation in high school and in college, really gave serious thought to public service. So I knew that I wanted to do something in that arena for a period of time and never dreamed that it would be a career. But the criminal law grabbed me from the moment I got here through my graduation, and the dean and I talked about working in the great Manhattan DA's office. And Frank Hogan, who had been district attorney since 1948, was an elderly man when I applied to the office, and he had changed the way most prosecutors' offices in the country worked. He had changed them from being political clubhouses to merit appointments of bright young lawyers who wanted to do public service. And he had one major flaw, which was that he didn't think women in the workplace, in his workplace, were appropriate. He didn't think women should be handling criminal trial work. And I applied to the office with the backing of the dean. There were 170 lawyers on his staff, 7 were women. No woman at that point in time had ever prosecuted a murder case in New York. And he didn't believe women should be standing in front of juries talking about violence and blood and guts, and forget sexual assault. We didn't even get in the courtroom, as I'll explain with that. And I went for my first job interview, and Mr. Hogan said, and I only got that interview because the dean of this law school made a phone call to Frank Hogan. They had worked together at Columbia University at the law school. And for that reason, Mr. Hogan saw me when he wasn't seeing many women. And he said to me in that interview, "This work is too tawdry for a woman of your educational background." Bob Morgenthau, 85 and the sharpest legal mind in the country and running again for re-election, liked to joke that obviously I thrived on tawdriness because 25 years later, there I was. And I applied to that office, and it was really only with the support of the dean that I was able to get my toe in that door. Women at that time worked in the law library. We were allowed to do appellate briefs and arguments, but never near the criminal courtroom. We were allowed to work in the grand jury, and my first experience handling sexual assault cases was in the grand jury, where we presented cases. We were never to keep them and try them, but we were allowed to present the cases. And there were 12 students in my entering class, 12 law school graduates in my entering class, 11 men, and I was the odd person out. And we were literally rated in those days. We got our ratings from our supervisors by how many cases we could present to the grand jury a day. And we would stand in a room, 6 of us at a time, long counter, shoulder to shoulder, and most of the cases that came in, the overwhelming number of arrests, were drug busts and gun cases and crimes without citizens. They were professional police officers as witnesses. And you could do 12 presentations a day. If you had cops who were used to coming in, they'd stand before you, they'd put the gun on the counter, they'd give you the ballistics report, and if you knew what you were doing, you could prep the cop, get in the grand jury 12 times before they suspended for lunch. And then the occasional rape victim would appear. And there she would be standing, while 6 of us on one side and 5 cops on the other. And there was no way you could interview her in that setting. So the process began by taking the 20 minutes to leave her and go 2 floors down to your office and begin to explore the details with her. And unlike a gun case and unlike a professional witness, and with the emotion that almost always attaches to these crimes, a slow interview would be an hour or an hour and a half, explaining what the laws were at that time, and the laws were bad, determining if you had the evidence to go forward, dealing with the emotion and perhaps the breakdown. And then you go back up to the grand jury and maybe be lucky enough before the lunch break to get one sexual assault case heard before the grand jury. And the way that my career started was simply backhanded, because the guys all realized that they could get 12 cases done in the time it took to deal with one rape victim. And it became, well, Linda's so much more sensitive than we are, we'll let her deal with the women. And it was entirely backhanded. Nobody meant for any one person to begin to do the work, and it fascinated me. It was a challenge every time. And the saddest part about it was the state of the law, which I explained to Professor Smith's class this morning, and I will remind you of now. I know you're legal scholars. When I got out of this law school in 1972, in most states, in New York and in most states still throughout the country, our laws required corroboration. They required evidence beyond the word of a victim alleging a sexual assault. And rape was the only crime in the penal code that had that legislative requirement. And the laws read in most states that women were incompetent to testify about sexual assault unless there was independent evidence of the crime. And each state codified what that independent evidence was, and it came in three forms. There had to be an eyewitness, someone who had seen the assailant taking the victim to the crime scene or leaving the crime scene, and most ridiculously, watching the assault itself. And as we saw the tragedy in Atlanta on Friday and in the church this weekend in the Midwest, there are many crimes like homicide that happen in broad daylight with a lot of witnesses. Rape is not one of those. And yet we had to have somebody who could identify the rapist beside the victim. We had to have evidence of the sexual nature of the assault. It now comes in the form of medical protocols, evidence collected at a hospital, and the amazing things that forensic science can do with that now. In those days, there was not a hospital in America that had a protocol to deal with the examination of victims of sexual assault. There were no evidence collection kits, those of you who do rape crisis advocacy. Most hospitals in this country had no way to get the slides taken in an exam by a physician to a police laboratory with any kind of chain of custody to be examined and introduced in evidence. And the third piece was the requirement that force be corroborated. So an assailant who had a gun or a knife and said to a victim, "Don't scream, give me your money," and then sexually assault her, if that gun or knife was not recovered from him, if he was arrested at his job 3 weeks later without the gun, then she was deemed by the law to have consented to the act of intercourse at gunpoint because there was no proof that there had been force. And that was the state of the law when I started trying cases. There were, in the only New York Times story that I could find when I did my research, my nonfiction research for the book that I published first, in 1970 there were 1,000 men, more than 1,000 men arrested in New York City for sexual assault. 18 of them were convicted of the crime. Not because prosecutors were trying and losing those cases, but literally because the law did not allow us to take witnesses in the door. So I'd meet people as credible as any one of you every day and have to read this law to them and turn them away and explain why they were incompetent. And a woman who had been coming out of Grand Central Station, held up at gunpoint at midnight, robbed and raped, was allowed to go to a lineup. She could identify the assailant. She could testify about the robbery without any corroboration, either of ID or force or whatever was taken didn't have to be recovered. And if at the same act the assailant took her back inside Grand Central to a tunnel and raped her, she was not allowed to testify about the rape in the same trial at the same encounter because there was no corroboration. And that didn't change in most states till the mid-1970s when corroboration was eliminated. And when that was happening in New York, the New York Times lead editorial called it abhorrent. The word they used was, it's abhorrent to think that a man could be convicted of rape on the unsupported testimony of a woman. And yet we could convict people of murder on circumstantial evidence without an eyewitness every day of the week. That bit of legal history, it comes from a case opinion written by Sir Matthew Hale, Lord Chief Justice of the King's Bench, very eloquent opinion that he wrote in which I'm paraphrasing without his artfulness, but it basically said that because rape is so easy for a woman to allege and so difficult for a man to defend against because it's so prejudicial, we have to examine the testimony of rape victims with more caution than any other kind of crime. He wrote that opinion in the year 1671. And in every state and territory as we developed, some version of that law became the law in our states. And it was not until more than 300 years later in most states in this country that it was eliminated from the books. So our unit was created because finally the law allowed prosecutors to go into the courtroom. None of us knew what we were doing. Nobody knew, we barely knew with police how to investigate these cases, and we certainly didn't know how to prepare for and try the cases. We tried to do very creative things with our little unit. We worked closely with the police. We become involved. As with homicides in New York, the moment a police report occurs, the detectives work with us so we can gather evidence, so we can do it with a view to preserving it and getting search warrants so that any property recovered, for example, from a defendant's home or his person can be introduced into evidence. We don't wait for the police to finish a case and sort of turn it over. So we've been very proactive from the beginning. On the lighter side, we did, in the 70s even, some very creative things. We had, I think the first case that was high profile for my unit was the case involving a dentist in New York who had been charged with molesting patients under sedation. A young woman in her 20s, went to this man. He had a very long, distinguished reputation. He practiced in Chelsea, terrific list of patients. This young woman went into a police station. She said, I came out of the anesthesia in his office. My clothing was in disarray. My vagina hurt. And I think this man was kissing me as I came out of my haze. And the detective took the report. He went to the dentist's office. He accused the dentist of these acts. And the dentist pulled a brochure from his drawer and said, this drug causes hallucinations. So obviously, this young lady was hallucinating. The dentist believed him, closed the case. 4 months later, a second young woman in her 20s went to the same precinct with her boyfriend, told a very similar story. This time, the detective didn't even have to leave his desk. He opened his drawer, had a Xerox of the brochure, said to the young woman, that's a hallucinatory drug. Nothing happened to you. Go home. Forget about it. And about 6 months later, when the third young woman came into the same precinct, the dentist called and said, there's either something in this guy's water or these women are hallucinating. The police started an investigation with us, and we realized that there was literally no way to determine what had happened, even if we sent young women back in, which was a dangerous thing to do, because the conduct didn't require any conversation, any speech, and we didn't want anyone else to be sedated. So the first young woman who agreed to go back in was wired up, much as we would do in an organized crime investigation, and as everybody does on television these days. But she was fairly bold, and she went back and accused him of things, and he denied everything, but did offer to meet her later with what he called his bag of tricks. And we thought we were on the right path. So the next thing we decided to do, it was the first time it had ever been done in the country, and we applied for an order to do a legal burglary in his office, as you would do in an organized crime investigation with a wiretap, but we couldn't use a wire. We needed a video recording to let us see what he was doing with these patients. And we were able to get that in a decision that went up to the Supreme Court. Our state court trial judge gave us, signed the court order. We had a tech unit, very primitive at the time, that went into the dentist's office the night before and installed a hidden camera in the air conditioning duct over the chair. And literally the hardest part of the case was to find a policewoman, a young policewoman, who had an abscessed tooth. Someone who could be sedated, who would need dental work and not just a filling. We couldn't find one in New York City. We had to go to the suburban New York. We found a terrific young woman who said, you can do it, I'll be sedated, but, and since it was on video, we knew we could break in. Her partner would pose as her boyfriend, and we said, when it appears that he's going to begin to touch you, she said, he can touch me, but nothing more invasive than that. We're not waiting for a rape here. So everybody was in agreement. She went into the dental chair. He sedated her. We watched the whole thing. She immediately looked unconscious, if not dead. And the dentist, in his, we think, excitement to get to her body, actually pulled the tooth and pulled the wrong tooth, which was a separate lawsuit against the city that she had very successfully later on. And then, much to our surprise, the dentist lifted her out of the chair. None of the women remembered this, of course, because they were sedated, but he actually lifted her out of the chair. Very dangerous thing to do because the oxygen flows from the brain medically, and so she was in even more danger of the drugs affecting her brain and not letting her recover as quickly. And he began to undress her. And he began to undress her in front of the camera and to molest her and to start squeezing her, or massaging her breasts and squeezing her buttocks. And at that point, the signal was given, and the partner broke in and put him back in the chair. And we all thought, of course, the dentist would be shocked. Here are these New York detectives rushing into his office. And he was very calm. He put her back in the chair and said, why are you here? They said, you're under arrest. He said, why? She's in respiratory distress. And I was just resuscitating her. The case actually went to trial. He waived a jury. He tried it before one of the few women judges in New York at the time, who was a very tough judge. And her ruling at the end of the case was that squeezing the buttocks of a woman was not a known means of resuscitation. And the dentist was convicted. And it was Another study it was 1977 when I tried that case. The New York Times, all the newspapers in the city we have a press room like most large prosecutor's office, and all the newspapers were in the building. And the New York Times reporter said, "I would love to follow your work, but I can't come to the trial because our readers aren't interested in sexual assault." And so we were only material for the tabloids in New York, the New York Post and the Daily News. And while the Times would not write about a healthcare professional in New York who was using prescription drugs to sedate and molest patients, the New York Post, on the other hand, was characterizing these cases the way most tabloids did in those days, with the headline, "DDS, Dentist Desires Sex." So our next biggest battle, in addition to legislative reform, was to try and educate about issues and attitudes related to sexual assault. We worked very hard and creatively with the police through the 1980s, as much doing legislative reform, prosecuting cases, and also speaking to as many community groups, people who would be our jurors eventually, to educate about these subjects. And it was in 1986 that I heard for the first time what are now my three favorite letters of the alphabet, DNA. And that was literally halfway through my legal career. We had done all of this work and made many prosecutions possible. I was working on a murder case when the chief medical examiner called me to tell me about DNA and tell me that it might be a way in this murder case of connecting the murder weapon that had been used to suffocate our victim. We had, at that point in time, no way to make the connection. And so in 1986, there was only one lab in the country, the lab at Quantico, that was doing DNA work for every prosecutor's office in the country, those that even knew about it. We sent the jacket down. It was a piece of the victim's clothing. It took 6 months to get a preliminary result. And so it was now 1987 when we got that result, which did connect what was saliva on the jacket, not visible, not blood, but her saliva was on the jacket, and therefore we could prove that he had suffocated her with that piece of evidence. We had a 3-week hearing, a Fry hearing, on the admissibility of the evidence, the reliability of the scientific technique, and the judge ruled that it was inadmissible, that this DNA stuff was too new and experimental and wasn't going to be valid in the long run. So the jury never heard about the connection between the evidence and the victim. I told this morning's class, I think the first 3 years, till 1989, when DNA was accepted in trial courts for the first time as a valid technique, was enormously frustrating for police and prosecutors. We could use it every day to identify people in crimes. We could use it every day to exonerate people. There was no problem using it, as we did, to prove that somebody had not committed a crime. But in those cases where it did identify and did match and did take the burden off the victim from testifying in court as the only form of evidence in the case, it was enormously frustrating to think and to see that it wasn't admissible and couldn't be used. There aren't words for me to describe enthusiastically enough how DNA has revolutionized the criminal justice system. It is absolutely extraordinary. We use it every day. We can get results in 24 hours. I could take not only the bottles and glasses you drink from and get them tested and bring them back tomorrow and give you each your own can or glass or bottle, but now obviously from skin cells, as you've all seen on CSI and Law & Order SUV, we could take, SVU I guess, sorry, we could, made that mistake before, take the clothing off your back and bring that back tomorrow as well and give you each the same piece of clothing that can be identified. One of the most remarkable things that occurred after 9/11 was working with the serologists at the medical examiner's office in New York. The first 5 days after 9/11, the group of serologists and the team of 12 that were the core there that did our DNA work every day never left the morgue, working around the clock. They literally, the first 3 days, they claim, nobody claims to have slept and just worked on adrenaline and working on identifications from the World Trade Center. And then they began to bring sleeping bags and cots, and after 5 days they realized that this was going to be a process with millions of pieces of human flesh to identify that was going to take years. And just 2 weeks ago, the chief serologist announced that they have now identified all the remains possible to do with the current process of DNA. But the science, the scientific technique is evolving so constantly. It's changed enormously in the 15 years since it was introduced. There's a very different kind of scientific process now used than was used in its infancy, and it will continue to get better. And there's no question that 5 years out from now, with the minuscule pieces that are left, that the serologists at that lab and at every lab in the country will be able to identify remains that are that fragmentary. These are the same serologists who are now in waves going to Asia and working on tsunami victims and can identify the barest remains from pieces of bone, from fragments of hair to make matches. And so it's extraordinary what has happened within the criminal justice system. And obviously when I say that, both for reasons that allow us to charge and convict people of crimes, but also because the importance of exoneration, the ability to do that and get cases that don't belong out of the system. One of the most interesting cases that I worked on right before I left was a serial killer, and we don't have a lot of them in Manhattan. This was a 28-year-old man who was a very smart computer software designer, and we had an unsolved series of cases of teenage girls who'd been murdered in housing projects over a period of 8 years and never anybody caught. And the police began to re-examine the cases, and were looking at, and the reason for the re-examination, the crimes had occurred in '98, but it wasn't until there was a DNA data bank that the cases were matched to each other. So we knew that 5 of these children, really 13, 14, 15-year-old girls, had been murdered by the same person. We didn't know who that person was. And the police went back and became interested in the suspect, who was eventually convicted, because he had been, this computer program operator, had been one of the last people to see one of the victims alive. Very smart, very cooperative, so police thought he was a good guy and a helpful witness. But when they went back, he became a more and more serious suspect in 2001, and they began to follow him. And I got a call one day from the detectives who were standing in front of a CompUSA store on Fifth Avenue, and they said, he's just gone into the store, and cops have gone in, uniformed cops have gone in to arrest him because he had a stolen hard drive that he was trying to sell back to the store. They said, you know, what do we do now? Can we charge him in our case? Can we get his DNA? Well, we had absolutely no probable cause, so I said, no, just stay with him, go back to the precinct, make sure that the misdemeanor theft case doesn't get dismissed. And I called the lab, and I said, this is a stupid question. I said to the serologist, but the only thing that I can get from his apartment with probable cause is his computer because of the hard drive, the stolen hard drive issue. You know, but that's useless. And that was the first time in 2001 that the serologist said to me, get me the mouse, do a search warrant, get the computer, because from the skin cells on that mouse, I will be able to match it to the evidence from the homicide cases. And I was drafting that search warrant when Aaron Key, the assailant, asked the police for coffee. And the guys called me and said, you know, don't worry about the warrant. We now have a coffee cup with his saliva on it. And it was that coffee cup which ended up linking connecting him to the homicides of 8 teenage girls and the rapes of 4 others that had gone unconnected and undiscovered for more than 7 years. The other thing that he did, I think the other wave of the future in criminal laws, is the internet and all of the uses of the internet and how much information we're getting from that in criminal investigations. He'd done something that none of us ever had dreamed of an assailant doing. He would go home after every murder. They usually occurred between 9 and 11 at night. And he'd wait 5 or 6 hours, and then early in the morning, he would go online and go to America's Most Wanted or the NYPD website, and he would plug in the location at which he had just committed this murder, and he would look to see what evidence or what information was being posted on the website. Had anybody seen the assailant? Were there any witnesses who were alive to describe who had left the crime scene? And all of these cookies and all this information was left on his browser, and when the police forensically interrogated his computer, there was all this additional evidence connecting him to the victim in each case. So it was a startling investigation in every way, and fascinating to me in both the uses of DNA and what came to be the evidence that we obtained from his computer. One of the things that we also did in the office before they did it on television was create a cold case squad, which is, again, another interesting experience that we've had. One of the things that DNA allows us to do is go back and re-examine cases that remained unsolved despite the best detectives, despite the most cooperative witnesses. And in New York, we had, at the time our DNA data bank went online in 2000, we had 16,000 evidence collection kits from rape cases that had never been tested because there had been no means to do it, and it was before DNA analysis had been in place. And Rudy Giuliani, to his credit, found the money to outsource those kits, send 16,000 kits to private labs to have that evidence developed. And starting 6 months later, every time 100 cases came back, they were coming back at the rate of about 100 a month, 15 to 20 old rape and homicide cases were being solved. And detectives would knock on the doors of people who long ago thought their cases had been closed, knew their cases had been closed, and tell them that the assailants had been found. And in many cases, we've been able to prosecute the old cases. 2 weeks ago, I got news from my successor in the DA's office, Lisa Friel, who's a UVA graduate, I think 10 years after I, and she said, we've now solved the oldest cold rape case in the country, a 1972 case where the defendant jumped bail in the middle of the trial. There was no DNA analysis at the time. He was caught in another state for another crime, and the police still had the bed sheets from that 1972 case, sent them to the lab, did DNA analysis. It's a very hardy substance. It is able to survive long times under very bad conditions. And the DNA matches this man who jumped bail in 1972, who will now be prosecuted for that rape. So that's really extraordinary stuff. Just a little bit about the transition. The nonfiction book, the dream that I had of writing was something I held on to throughout the practice of law. The nonfiction book was something that I was asked to do because of all the legislative reform. And so, although I hadn't thought I could do both things at once, it was the completion of that book in '93 that allowed me to go on to what I had always dreamed about, which was to write crime novels or murder mysteries that are procedurals following the life of a prosecutor. And what I love about it is, while they are meant to entertain, they're also meant to educate, so that people who would never go into a bookstore and buy a book called Sexual Violence, and there are many of those people, will buy for an airplane ride or a beach book a murder mystery that has all of the same elements and all of the same information. In the new one, which has a little to do with Charlottesville because it's got a lot to do with the life of Poe. Thank you very much. Thank you very much. There's a little bit of a point that has to do with the law, but the new one has a lot to do with the life of Poe and the fact that NYU Law School in New York bought a house in which Poe lived in New York. And having spent time on the lawn here, I knew Poe was a local, and I always thought of him as a Southerner, so I was surprised to see how much of a New York presence he had. And that took me into exploring his life. But one of the great things about fiction, sort of one of the cases that haunts me the most is an unsolved serial rapist who was attacking women, more than 20 women connected by DNA on the Upper East Side of Manhattan. And then one day he disappeared. He just never attacked again, and generally guys as proficient as he was at the work don't retire. He may go to jail for a while or be in another jurisdiction. So we waited for him to come back, and he had finished the series in 1995, and we knew that our 5-year statute of limitations was about to run, and that he could come back and there would be no way that we could prosecute him for the earlier crimes. And I read on the front page of the New York Times one day about a prosecutor in Milwaukee who was trying something new. I hated that somebody thought of it before we did, but it was a great idea, and he did it with a serial rapist, which was indict the DNA of the rapist, indict the rapist as John Doe, whose DNA profile is, and spelled that out in the indictment, and didn't have a clue who the rapist was, but would toll the statute of limitations by arresting and charging John Doe. So I ran into Morgenthau, who said, try it, and the Wisconsin guy's been caught, and California's John Doe, and I think 3 of them in Texas have been caught, but we still don't have our guy. And the beauty of fiction is my character does a John Doe DNA indictment and actually gets the rapist. So it's one of the nice ways to get things done that I was not able to get done in real life. I know we're going to open it up to questions. I just also have to say about the scholarship in my name. I neither had the means from the public service career at that point before I was writing, nor particularly I didn't need my name on the side of a building or a room or whatever, but I think the thing of which I am most proud in my career was my classmates, my very good friends who funded this scholarship in my name, and to meet Katie Bagley, and one of the people who's had the honor of being the scholar. It's just a wonderful, wonderful thing to me. So now that I'm writing books, we hope to fund this scholarship a lot more seriously than my public service career allowed me. I know you're going to go in a variety of directions. You will all have wonderful careers. This great university, this great law school has prepared you for them well. I hope many of you consider some period of time in public service, and if not, in your private practice, some way to give back, some way to do some kind of public service work, because it is not only challenging and endlessly fascinating, but it is very, very richly rewarding, and has given me a career both with, as I said, literature and the law that makes me proud and happy every single day. So I'm going to stay and take questions for as long as you can stay, but I thank you all for coming, and I thank you, Dean Jeffries, for having me back. Not necessary. Thank you. Question? Oh, no. And actually, Friday night, David Baldacci, UVA grad, and I will be doing a program at the book festival, so come hear us. You don't have to buy books.
I don't know if you noticed that last little bit, David Ibekin from the Law School Foundation was nodding vigorously.
Who had a lot to do with getting everybody together on this scholarship.
I'm sure about the rest of you. I may never drink coffee again. Linda has agreed to take questions, and we will, in just a few minutes, open to a reception to your left, our right, and we hope you'll stay after the questions and have the opportunity to talk with our guest individually.
Now, when I came to law school here, I told the class this morning, we had Ladies' Day. Some of you here, do you remember that? Did you at your class have Ladies' Day? And Professor Dillard would stand in front of the room and he said, just ladies on your feet. There were maybe 3 of us in the big section then. And I remembered after telling your class, my case was McPherson v. Buick. That was the source of embarrassment for at least a half hour on my feet of my first year. So somebody ask a question. You're all not that shy. Sir.
I'm interested in the John Doe indictments and why legislative reform trying to extend the statute of limitations was
Legislative reform is a great idea. It's just slow. So we're approaching it from both ends. The question about John Doe DNA indictments and why we haven't attacked the same thing by legislative reform. Generally, in most states, the defense lobby is very, very powerful. So most states, New Jersey's extended the statute of limitations. New York has done it by case law. We've had pending legislation for more than 5 years that has not been successful. I think California has extended. So we're doing it both ways, and I think the future with the reliability of DNA, and as the process has changed, I think you'll see that legislation in most states, but it's been very actively opposed throughout the country. Yes, in the back. Well, cold case, I mean, what am I thinking? CSI Miami, Charlottesville, whatever shows make me crazy. They are the worst. Nothing happens like that. Nobody has Hummers. The women do not run around in low-cut little T-shirts poring over evidence. And really, on the most technical end, the evidence collection guys don't do anything else in the investigation. They are supposed to process, and everything else they do at the crime in the case relies on their processing of the crime scene perfectly, expertly, and all of this forensics explodes in a courtroom because the defense knows the jury expects to have it, and when it's not there, they can make great hay of not having it. But that one's completely unrealistic. Those crime scene guys would not be interviewing suspects and would not be talking to witnesses and would not be running the case. They very quietly process the scene and get out. Dick Wolf, the whole Law and Order franchise, he's a little more interesting because he uses a lot of retired detectives, a lot of retired prosecutors. He takes his cases from the headlines, and the funny thing, in New York, he uses so many of our cases, he solves them before we do. He gets them to trial long before we do, and we have actually had the problem of jurors who come out of a jury room and send a note out saying, well, you know, I know that the defendant was in Puerto Rico the night that crime happened because I saw it on, you know, and we've had entire, you know, we've had trials postponed when they've been on SVU, because sometimes what he does is when he knows a trial is coming, he'll put the show on right before the trial, and you get jurors who think, well, if the case is that real, then, you know, he's using the real killer or the real, so it's created a monster in many ways. It's in a sense, these shows have educated the general public, but to the point where they really expect every case to have dazzling forensics to solve them, and it doesn't happen much of the time. So I prefer to read than to watch these shows on television, but that's the writer in me. Yeah. Well, no, it was part, the women who came before, mostly women, and sadly, I mean,